The Law Council of Australia is grateful to the International Bar Association's Human Rights Institute, Human Rights Watch, and the International Service for Human Rights for the opportunity to address this side event at the 31st session of the United Nations Human Rights Council today. The extradition bill proposed and under consideration in Hong Kong has raised and continues to raise concern within Hong Kong and around the world in recent months. We thank you for the opportunity to make a statement on this important issue and thank you for your interest. Respect for the sovereignty of our neighbours is a fundamental pillar of international law. So too is respect for human rights. The rule of law knows no borders. As lawyers, regardless of where we practice, we have a common obligation to defend and promote the rule of law, the administration of justice, and meaningful protection for human rights. Australia has long enjoyed a close friendship with Hong Kong and with the People's Republic of China, as have our respective legal professions. Being a true friend and true ally of any nation means that when issues arise in a foreign justice system that impact upon Australian citizens or on the right of lawyers to practice, we are obliged to speak up, to raise these issues respectfully but frankly. We do no one a service by ignoring them, least of all our friends. The Law Council of Australia is the independent national representative body for Australia's legal profession. We are committed to working and advocating for the improvement of the law and the administration of justice domestically and internationally. It is in this spirit that the Law Council expresses concern today over the Fugitive Offenders and Mutual Legal Assistance in Criminal Matters Legislation Amendment Bill 2019, which was gazetted in March 2019 and has been under consideration in Hong Kong. Of particular concern to the Law Council is the proposal to remove the prohibition on extradition between Hong Kong and mainland China. This prohibition has been in place since the transfer of sovereignty over Hong Kong. If legislated, this proposal would give extensive discretion to the Chief Executive to enter into special surrender arrangements. These arrangements would permit ad hoc extradition of any person in Hong Kong, not just residents, to any state with which Hong Kong does not have an extradition treaty, or between Hong Kong and mainland China, Macau and Taiwan. Australian law currently allows for extradition to Hong Kong under the Extradition Act 1988 and regulations for a range of offences punishable by imprisonment or other form of detention for more than 1 year. This Act critically provides a range of safeguards and grounds for refusal to permit extradition, including where there are substantial grounds for believing the person has been or will be subjected to torture or other cruel, inhumane or humiliating treatment or punishment, where the person may be discriminated against on specific grounds, where the offence is a political or military offence, or where the person would be exposed to double jeopardy. The agreement for the surrender of accused and convicted persons between the governments of Australia and Hong Kong was established in Hong Kong in 1993. Article 19 of this agreement imposes a restriction on Hong Kong from being able to subsequently re-surrender a person to another country unless it has either Australia's consent or the person has had the opportunity to leave Hong Kong and has not done so within 14 days. These are critical safeguards. Once a period of 40 days has elapsed, the protection of Article 19 is no longer available to the subject of the extradition application. If a person does not leave, that means Hong Kong is able to have that individual re-surrendered. The Law Council is concerned that if the proposed bill is passed, Australians who have been surrendered to Hong Kong, who have not been able to avail themselves of this protection, will become liable to re-surrender to the People's Republic of China. The risk of extradition to China posed to Australians and other nationals located in Hong Kong is significant for several reasons. Concern has long been expressed in Australia about the rule of law in China. Specifically, concerns have been raised as to the shortcomings in the quality of justice in China. These concerns include denial and harassment of defence lawyers, which we say can never be tolerated, inconsistent with the United Nations basic principles on the role of lawyers. Regrettably, corruption within the judiciary, political interference in trials, a denial of procedural fairness or due process, prejudgment and bias are amongst other issues. There have been frequent reports of the torture of prisoners to extract confessions or to punish, the holding of prisoners in detrimental conditions, and even organ harvesting from prisoners. Australia reserves the right to refuse the surrender of its nationals under Articles 3, 6 and 7 of Hong Kong's 1993 extradition agreement with Australia. However, if this proposed bill is passed, courts in Australia called to consider requests for extradition made by Hong Kong will be wary of the risk of re-surrender to China. This is in light of its record in relation to human rights and perceived disregard for the rule of law. This approach has been adopted more recently by courts in New Zealand, which have noted wide-ranging concerns that surrendering a person to the People's Republic of China would not be consistent with New Zealand's own international human rights obligations. Australian courts may be also reluctant to order the extradition of any person to Hong Kong should Hong Kong pass the proposed bill in its current form. This would be regrettable for the criminal justice system of Hong Kong. This is not the first time Australia has had cause to consider these matters. Similar concerns were raised on a previous occasion in the context of a proposed extradition treaty between Australia and the People's Republic of China. The Australia-China Extradition Treaty was signed in Sydney in 2007. It has never entered into force because it has not been ratified by the Australian Parliament because of concerns in relation to the Chinese justice system. Australia cannot allow a person to be extradited to a country where there is a risk that the person will then be extradited to the People's Republic of China given the current system of justice in that country. This is especially the case where China may be able to exert political pressure over Hong Kong to facilitate the extradition of individuals to the Republic in accordance with the extradition arrangements proposed by the bill. Extradition is an important mechanism to promote the administration of justice and deal with those accused of serious criminal offences. The fundamental purpose of extradition is to bring a person before a court to face a fair trial so that their innocence or guilt can be determined through a transparent process and an appropriate sentence determined. The International Covenant on Civil and Political Rights requires that any punishment imposed following extradition must respect the inherent dignity of the convicted person and must not amount to torture or cruel, inhumane or degrading treatment or punishment. There is a concern as to whether this can be achieved in the People's Republic of China in the absence of an independent legal profession without safeguards to ensure defendants receive a fair trial and where there is a possibility of political interference in judicial proceedings. The basic principles on the role of lawyers exist to protect individuals who are charged and promote a fair trial by ensuring they are able to access the lawyer of their choice to act for them without fear or favour. The principles also protect lawyers who are called to act for unpopular persons or persons who a government alleges to have broken the law. The Law Council respectfully submits that any suggestion that the principles have been violated by the People's Republic of China must be carefully investigated out of both fairness to China and those who make those allegations. In conclusion, in the absence of urgent reform, it is the carefully considered advice of the Australian legal profession that extradition arrangements with the People's Republic of China may place extradited persons at risk of punishment that is inconsistent with the fundamental rule of law principles and international law and incompatible with Australia's own obligations. Members of the Hong Kong Bar have provided similar carefully considered advice to Hong Kong legislators. It is vital for every nation to have an independent legal profession that can practice without fear of reprisal. As beneficiaries of this freedom, it is important for lawyers to work across jurisdictions to protect the rule of law and our colleagues, including exposing conduct by China that is inconsistent with international law. We encourage the Hong Kong Parliament to calmly and carefully consider these concerns, the implications of the proposed bill on Hong Kong's extradition regime, and appropriate safeguards in full consultation with the community and the legal profession. And we encourage open, honest dialogue across the region to safeguard human rights and speak up in defence of the rule of law. Thank you.